10 of the House of Commons Standing Committee on National Defence. Pursuant to the motion adopted on October 23, 2025, the committee is meeting to commence its consideration of Bill C-11, an act to amend the National Defence Act and other acts. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person and some are remotely using Zoom application. Before we continue, I ask all personal participants to consult the guidelines on the table. These measures are here to help prevent audio and feedback incidences to protect the health and safety of participants, including the interpreters. I'd like to also remind the witnesses and members to please wait until I recognize you by name before speaking. For those participating by video conferencing, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. And for those on Zoom, at the bottom of your screen, you can select the appropriate channel for interpretation, either Floor, English, or French. And for those in the room, please use the earpiece and select the desired channel. Again, all comments should be addressed to the chair. For members in the room, if you wish to speak, please raise your hand. And for members on Zoom, please use the raised hand function. The clerk and I will manage a speaking order as best we can. We appreciate your patience and understanding in this regard. Now, as I welcome the witnesses and the members around the table, we are pleased once again to have the Honourable David McGuinty, our Minister of National Defence, with us. We have General Jenny Cardigan, Chief of Defence Staff of the Canadian Armed Forces, Stephanie Beck, Deputy Minister, Lieutenant General Paul Provost, Chief of Professional Conduct and Culture, Major General Rob Holman, Judge Advocate General, Canadian Armed Forces, and Martin Gravel, Chief Operating Officer, Sexual Misconduct Support and Resource Center. I will now invite the Minister to make his opening statement. And, sir, you have 5 minutes, only 5 minutes. Over to you, sir.
Thank you, Mr. Chair, with military precision, as always. Mr. Chair and committee members, thank you for inviting me to appear before you as you begin your study of Bill C-11, the Military Justice System Modernization Act. Before we begin, I want to acknowledge that the topics that will be raised in these committee proceedings are of a sensitive nature. The Sexual Misconduct Support and Resource Center has a 24/7 hotline. If you feel the need, anybody watching or participating, dial 1-844-750-1648 for assistance at any time. I also want to thank you, sir, for arranging a special sitting of this committee to accommodate my appearance today. Members of the Canadian Armed Forces work very hard every day to defend the values of peace, freedom, and democracy, both at home and abroad. And they do it with unwavering dedication, professionalism, and resilience. We've all met with our forces across Canada and around the world, all of us. Their work has always been essential to Canada's security, but in today's unpredictable and volatile geopolitical environment, it has taken on renewed urgency. It's our responsibility to ensure they have a workplace where they feel protected, respected, and empowered to serve. That means eliminating harmful behaviors from our institution, including sexual misconduct. The
changes proposed in C-11 respond to key recommendations made in independent external reviews conducted by former Supreme Court Justices Arbour and Fish to ensure the transparency and accountability of our system and align it with Canadians' expectations.
First, Bill C-11 will remove the Canadian Armed Forces investigative and prosecutorial jurisdiction over criminal code sexual offences committed in Canada. This means that all criminal code sexual offences will be investigated and prosecuted exclusively in civilian criminal courts, addressing part of recommendation number 5 in Justice Arbour's independent external comprehensive review. Second, it will address 8 recommendations from Justice Fish's third independent review, including modifying the appointment process for the Canadian Forces Provost Marshal, the Director of Military Prosecutions, and the Director of Defence Counsel Services, allowing non-commissioned members to be appointed as a military judge, expanding the class of persons who are eligible, affirming the Judge Advocate General's respect for the independence of authorities in the military justice system, expanding the class of persons who can make an interference complaint, and changing the title of the Canadian Forces Provost Marshal to the Provost Marshal General, aligning it with other senior CAF designations. Third, Bill C11 will remove military judges from a summary hearing system and expand access to victim liaison officers under the Declaration of Victims' Rights to individuals acting on behalf of a victim. Lastly, it will amend the National Defence Act to align sex offender information and publication ban provisions with the amendments made to the Criminal Code in 2023. Together, these amendments will bring our military justice system in line with our civilian criminal justice system, ensure it better responds to the needs of survivors, and ensure confidence in our institution. Ces réformes législatives s'inscrivent.
These legislative reforms are part of a broader effort to transform the culture of the Canadian Armed Forces and to make them more inclusive and representative of the people we serve. Those who do not meet these requirements will be released as soon as possible. We have also modernized dress requirements and made other improvements to attract and retain more women and ethnic minority Canadians.
We've also made progress on recommendations number 7 and number 9 of Justice Arbour's report. CAF members who experience sexual misconduct, sexual harassment, crimes of a sexual nature, or any other form of discrimination based on sex or gender while performing their duties can now bring their complaint directly to the Canadian Human Rights Commission without first exhausting internal grievance and harassment processes. We believe these are all steps in the right direction, but our work is far from over. Le projet de loi C11 constitue.
Bill C11 is another crucial step towards this ideal, reinforcing our commitment to protecting Canadians, supporting survivors, and strengthening trust in the Canadian Armed Forces.
Our responsibility, colleagues, to make sure our military justice system is fit for purpose. And I thank you for your part in helping us keep it modern, relevant, and responsive. I very much look forward to working with this committee as you examine the bill. I'm happy to take your questions. Thank you again for allowing me and my officials to appear today. Merci beaucoup.
Thank you, Minister. That gave you some leeway. A few extra minutes would have been fine. No, not at all. Because we're taking it away from James Bazan, our first questioner. Stan, you only have 2 minutes. Over to you. 6 minutes.
Thank you, Mr. Chair, and thank you, Minister. I just want to start off by saying that the official opposition, as Conservatives, we believe that everyone in Canada, but especially those that put on the uniform in service to Canada, should never have to deal with sexual misconduct, racism, and discrimination. And we believe that this bill is the first good step. Now that you've brought forward Bill C11, it's been over a year since this House originally saw Bill C66. As the new minister on this file, did you consider making any changes to the bill before retabling it?
That's a really good question. I felt, looking at the bill and getting briefed on it, Mr. Bazan, that it was the right form now to enhance trust and transparency in the system. What we did hear back and what I did insist on was getting briefings and feedback from folks, people who were applying, for example, looking to enlist, to sign up to join us. And they told us in very large numbers and in no uncertain terms, they wanted a 21st century workplace. And so they felt that this balance of measures, which we could deliver quickly and hopefully pass quickly together by all party support, I hope. The Canadian Armed Forces, I think, told us they were counting on us to get it done.
Okay, so there was some recommendations that came out of the work of this committee in the past, including November 2024, we had the Rebuilding Trust, Transparency, Accountability in D&D and CAF. That wasn't taken in consideration in the new bill that you brought forward?
I don't think the details of that were, but okay. Again, one of the reasons we're here is we're very open to hearing more from all members about how to improve this bill.
December 2021, even without the legislation, Canadian Armed Forces has been moving all sexual offenses that are criminal in nature over to the civilian system. Do you know how many cases have gone forward into the provincial justice system across the country?
I can't recall personally, but I know somebody at this table does, if you would.
Okay, well, then
permit
we'll,
me.
we'll get to that in the
Okay.
second hour.
Okay.
So you don't know if there's any cases that have been delayed and that the Jordan's framework has come into play?
Not in my briefings, no. What I've been
Okay.
told, in fact, is we made great progress with Ontario in signing an MOU on how to deal with these cases, that we continue to be in touch, close contact with all provinces, all jurisdictions, and we're very, very receptive as a two-way dialogue to make sure that we get these cases properly treated and dealt with.
Sworn in as minister, have you spoken to Justices Arbour, Fish, or Deschamps on this file? on
No,
this
I
bill?
haven't spoken to them. I've interfaced with Justice Deschamps in another capacity, but in terms of following up, I intended to do so after this hearing and when I'm back from travel this week.
Okay, so in this bill, there is going to be more people appointed through order in council. That'll be political appointments. Can you tell us why what's the rationale behind some being, 4 years, some are being 7 years, the ombudsman, a 5-year appointment? Now, why is there a difference there?
Well, I would begin by saying that the rationale for moving these appointments to a GIC appointment is because the structure and the transparency and the robustness of that process are, and we believe, superior to what exists now. It also helps make it plain that the notion of even the perception of chain of command pressures being brought to bear on these really important appointments would be overcome. And thirdly, Mr. Justice Fish wanted to align these positions with other positions in the federal government.
I think the standard is kind of like a 4 or 5 year, not a 7 year. Like I'm really confused
I
on
think,
this. But we'll get,
I think the Director of Public Prosecutions has a 7-year term.
okay.
So I
But
think
usually
it
people
depends.
in uniform serve about 3-4 years max in any position.
Yeah,
So
it could-
now we're going 5 and 7. It's one thing that we want to drill down a bit on. Now, in C11, it gives you, as the Minister of National Defense, the power to issue guidelines and directives with respect to particular prosecutions when they're used to be done by the JAG. Will that not lead to political interference potentially?
I would be hard-pressed to believe that any Minister of National Defense would want to insert themselves into a prosecution of this kind.
You were looking at Bill C11 and the department. Did you also look at other allied nations and how they have been doing this as it relates to sexual misconduct in particular? But, Australia and the United Kingdom have independent prosecuting offices, the way they've handled it. So have you take that in consideration?
We
and
did.
tried
We looked
to
at
mirror that?
comparative. Thank you. That's a good question. We looked at comparative practice. But what we really relied on was Madam Justice Arbour and Mr. Justice Fish and their wisdom and the benefit of all of their hearings and the thousands of folks they spoke to and the research papers and the analysis. And this is where they came down, and we support their views.
So why do you feel you need to have the power as Minister of National Defense to issue guidelines and prosecutions when that used to be done by the JAG? Why would the minister do that and not the Judge Advocate General?
That's a good question for the JAG, if I could.
Okay, we'll get back to it.
Okay.
I'll make sure we circle back on that one.
Thank you.
Was the Privacy Commissioner at all consulted on Bill C11?
No?
Because I'm just thinking about.
Don't think so, but
the Victims' Bill of Rights, and when people are referred into the
I
civil
don't
system.
think so. I'm looking down the
they're
table. I don't think so.
Victims' rights.
But that might be a very good witness to
Okay.
call.
Which provincial municipal police forces have you consulted on whether or not they have the capacity to handle the increase coming from the CAF when we were referring?
My predecessor minister dealt with a number of police forces and a number of solicitor generals and a number of,
As to who?
I'm sure we can
Howdy.
get that for you.
James, that's it. Thank you, Minister. James?
Thank you.
Vivian Lapointe, you have up to 6 minutes.
Members of the Canadian Armed Forces dedicate their lives to serving our country, and they deserve a system that protects them with the same integrity that they show in uniform. Can you tell this committee how Bill C11 helps to rebuild the trust and the confidence amongst Canadian Armed Forces members who may have lost faith in the institution's ability to hold offenders accountable?
We're on a journey of reinvigorating the Canadian Armed Forces collectively as a people. This is a very meaningful step forward towards advancing a culture of respect and accountability across the defense team. This is about a suite of targeted amendments to help bolster confidence in our system and in the military justice system. And these amendments build on a succession of independent and external reviews that have been conducted. What it also really does is give implementation to Justice Arbour and Justice Fish's recommendations that are legislative in nature. So as I said, recommendation 5 of the Arbour Commission and 8 separate recommendations from Mr. Justice Fish. It basically removes the military jurisdiction over criminal code sexual offenses committed in Canada. This is a big decision, but it's a very important decision, and it's the right decision. Because it is very, very important the Canadian Armed Forces not be in a situation where its members, its new recruits, its applicants, people thinking of careers, don't trust the system. And so what we're doing here is we have and we're going to continue to address the needs of those who've been affected by conduct or by harassment or crimes of a sexual nature. So as I said last week in a speech on Friday in Toronto, so we can expunge this behavior and move forward and build a highly performing, more than it already is, Canadian Armed Forces.
Thank you. You touched upon this in your response, but I'd like to expand, for you to expand upon it, because this legislation gives legal force to a key recommendation that came from Justice Arbour, ensuring that criminal code sexual offenses are handled exclusively by civilian authorities. Could you speak to how formalizing this shift in law will strengthen confidence in the process for survivors, and what additional steps will follow to fully implement this change across the forces?
That's a very big question, an excellent question. It is, look, as a result of this legislation, the investigation and prosecution of criminal code sexual offenses will now fall, as you say, under the exclusive jurisdiction of the civilian justice system. This was a strong finding of Madam Justice Arbour's review and her commission. This was very much about indicating to victims, to complainants, to people who are working or serving right now in the forces or in D&D, or those who are thinking of joining, that we're going to improve the architecture. We're going to make profound systemic changes. And there have been a whole series of these, which I'd like, we'll take more time to chat about when we have more questions. But this is very much, this recommendation is very much the cornerstone of Bill C-11. And we are convinced that it will have a major impact on building trust. Trust is fundamental to be able to recruit and to retain good people. And this is why this is part of our larger culture evolution efforts. And so there have been many, many other changes made systemically across the system.
Minister, this legislation has a lot. I think you said it addresses 8 recommendations. Can you outline or provide some examples of how this legislation directly advances the work that helps the government stay on track to complete the remaining recommendations by next year?
The good news is, before my arrival, a succession of team members, some of whom are sitting at this table, previous ministers, previous committees have worked together to facilitate many changes inside the system. What I found is reviewing all of re-examining the reviews that have come before. Each has built on the other. Each has led to systemic changes and systemic improvements. And this is why this is sort of not the crown jewel, but the last big piece we've got to get done legislatively. We're well on the way to, I think we've already, if I recall, we have implemented some 114 of 194, I think it is, total recommendations. If I have that number right, between those 4 fundamental reviews. In fact, with my experience in government, I haven't seen this before. I haven't seen a department organization take that many recommendations and actually operationalize them as quickly as they have.
30 seconds. Big question for 30 seconds, but can you talk about our commitment to institutionalizing culture change and how this legislation ties into that commitment that we've made?
It really did start from the top down and the bottom up at the same time. We had incredibly inspirational victims come forward and explain the impacts of this on their lives, which is beyond heart-wrenching, was very clearly unacceptable. That has led to an understanding that there was a fundamental challenge. This began years ago. These reviews were conducted years ago. And now we really want to move forward. That's why we devised, for example, a comprehensive implementation plan for all of these recommendations. Not randomly, but over a 5-year period, 23 to 28, looking at prioritizing and addressing all these 194 external recommendations. So none of them are left on their own. They're not stragglers. We fully intend to have these recommendations implemented by December of this year.
Thank you, Minister. Monsieur Savard-Tremblay, you have 6 minutes.
Merci, Monsieur le Président. Bonjour, Monsieur le Ministre.
Thank you, Mr. Chair. Welcome, Minister, and welcome to the team from the department. Thank you for being here. This is a sensitive topic, although we are talking about a solution here, and it is on the right track. Let's discuss a few points specifically. In the former bill, if I'm not mistaken, it was quite similar. That was Bill C-66. A number of victims, a number of people had been met with pursuant to the Arbor report, said that they hadn't been consulted before the drafting of Bill C-66. Can you say that for C-11 that has been remedied? People have been spoken to? Based on my understanding of things, Mr. Savard-Tremblay, there have been a high level of consultations outside of the department. Madame Tremblay, Madame Therrien, the external reviewer that I met for the 3rd time last week, in fact, is continuing her work. She is responsible for pushing the government to implement these recommendations, and she continues to reflect on this. She's continuing to support us and provide advice. Her 5th report actually was published in June, and all of that was considered in developing C-11. It depends on the review. The military college review, for instance, that had to do with 1,500 people. So the effort underway through these 5 reviews is comprehensive. So it goes beyond what was done for C-66. It's been ongoing since C-66. The dialogue is ongoing. The groups, the stakeholders, the NGOs are all involved. It's continuing, yes. I understand why that you would want this, the Director of Military Prosecutions, these appointments on recommendation from the Minister, the Judge Advocate General, Provost Marshal General, etc. I understand why, because General Vance was saying, hey, I'm in charge of the process. I'm never going to be released. There was no independence because the boss himself had control, directly or indirectly, on the legal process. Now things have politicized. Okay, people are saying, all right, let's have that be external. And Minister, I understand you weren't the minister at the time. This is not personal. And you weren't even in cabinet during those 9 years prior to your appointment here, I think in March, right? So for the first time, you are now in cabinet. But we know that since 2015, these stories have been ongoing, and there's been silence from your predecessor at Defense. So the idea is to have it less non-politicized. But insofar as there has been this secrecy or even buddy-buddy kind of relationships? How can we trust in this non-politicized process? I think the improvements under C11 include changes where the Provost Marshal General, the Director of Military Prosecutions, and the Director of Defense Counsel Services this has to do with an issue of perception. And it has to do with the influence of the chain of command within the Canadian Armed Forces. That's precisely what we've heard from the victims and stakeholders that were affected by all of these matters. So it's not about interference or political interference. It has more to do with the idea of having appointments that are open, more transparent, more predictable. I'm convinced that through these changes, we'll be able to help minimize mainly the perception that these positions are directly controlled by those in the chain of command, the superiors in the chain of command. I understand that. You've wanted it to be not a self-regulated process. You can't both be judge and jury. That's clear. That's the case here and in many other areas. You say it will be more transparent. From what I gather of the legislation, the government, through the minister, that's how, I mean, what else can be done to make sure there is no interference? Is there anything else that makes it clear that, okay, there is an appointment, but that is not under the control of politicians? Sorry, are you referring to the minister, the cabinet, or the prime minister, the governor general? Who are you referring to exactly? Let's say all of the above. There are many rules. There's a criminal code that covers politicians. There's the ethics code at the federal level. It's difficult for me to perceive a situation where a minister would want to take a risk like that, one of interfering in a matter of prosecution. How do you say that in French? Les poursuites, okay. Just to reiterate, the appointment process through cabinet will improve transparency.
I'm sorry, I couldn't hear what the chair's saying.
Ms. Hilder, I've just acknowledged that your raised hand is there, and I'm asking the committee for unanimous consent to enable you to speak, and we don't have it, unfortunately. So we're going to continue our second round, and it now goes over to...
With respect, Chair, I would like to use my own voice to ask for unanimous consent to ask questions about victims of abuse in the Canadian Armed Forces.
Okay, so Ms. Laurier, if you could just by all means request unanimous consent.
Chair.
You're not a... Yeah, do we have? No, the answer is no, and I apologize.
Chair,
you're not
I would like to ask questions related to victims of abuse in the Canadian Armed Forces. And
I appreciate that. And it's important that you do. Unfortunately, we have a committee underway, and we have our existing members that are part of this committee, of which you are not, unfortunately, and we must proceed because of time, and I don't want to take it away from the members. Mr. Kibble, up to you. You have 5 minutes.
I agree, and I greatly appreciate that you spoke to the importance of the sensitivity, the need for collaboration on this bill, so thank you for that. Which provincial justice ministers have you spoken to about this bill?
Which ones have I spoken to personally?
Yes.
None. Not since my arrival a few months ago, but I know that my predecessor spoke to a number of them.
Okay.
I'm not sure if they're all in the same positions now, but it was wide consultation amongst the provinces.
And which, thank you, provincial solicitor generals have you spoken to?
My understanding is the MOU we have with Ontario builds on a series of conversations with the Solicitor General there and the previous one, which led to this negotiation anchoring it, and now other provinces are being asked to look at the MOU as a possible model to follow. But thus far, no province has taken up that offer.
Were provincial ministers, police forces, or Crown attorneys or Crown Attorney associations consulted during the drafting of the
My
bill?
understanding is yes. Their feedback was solicited widely in up to and leading up to the drafting and the elements of the bill.
Thank you. And earlier you mentioned one MOU signed in Ontario. How many MOUs have you signed with civilian police forces regarding the exchange of information?
That wouldn't be
for,
something that we
CAF
would.
members?
That's a great question. It wouldn't be something that we would normally sign with the police of local jurisdiction. It's much more a question of prosecutorial capacity at the provincial level. The federal government would not necessarily enter into this kind of dialogue with local police forces.
Okay, so you mentioned the MOU you mentioned earlier
With the province of Ontario.
with the province of Ontario.
Yeah.
Have you entered into MOUs with the other provinces as well?
No, I was mentioning the offers remains. It's been shopped around. People have been, provinces have been asked for their feedback. That dialogue continues. There have been interdepartmental deputy minister and FedProv tables and so on. That work continues.
Thank you. Has there been discussion on a need for extra funding or resources to achieve these changes, given the extra cases being given to civilian
It
police
is something
forces
that we have
and
raised, something that we have
investigative, yeah.
examined internally. It's not something that we've come to ground on. It's not, none of the provinces have necessarily come forward in this regard, but it is also important to remember that it is the provincial responsibility to actually administer justice in the country.
So is the federal government considering extra funding for those services? For
Not
the
at this,
extra
not
duties?
at this point in time.
Okay. Have you looked at mechanisms used by our allies to administer justice on sexual misconduct?
My understanding is yes, there's been a widespread analysis of some of our partners, allies, what's worked, what hasn't worked, certainly the United States. I suspect Australia, New Zealand, and others. But this is a very Canadian approach, derived from 3 or 4 foundational reviews, the last of which was conducted by Madam Justice Arbour.
Okay, you mentioned the United States. Was that considered something similar to their model in the developing of this bill, similar to NCIS in the United States?
I think it was, although I would say today I'm not sure what the model would be in the United States. There are a lot of changes going on, so we're not sure to what extent that would be helpful in informing our approach.
Thank you. And there's nothing in Bill C-11 to compel civilian police to communicate with the Canadian Armed Forces. How will you make this happen?
To compel them to communicate with the Canadian Armed Forces?
Yeah.
Well, once a matter is transferred into the hands of a civilian police force, it's now part of the administration of justice chain. It wouldn't be something that the Canadian Armed Forces would be dialoguing with on a regular basis. If there's evidence, investigation, material, if an information has to be sworn, it would be transferred over to the police force, and then it's over to them and their provincial crowns.
Thank you. The bill says military police cannot investigate, so securing evidence is part of investigating. Can you comment on how military police will walk this fine line between securing evidence and not investigating? And would you be open to amendments relating to this in Section 70.2?
Did you mean outside of Canada or inside of Canada?
Specifically inside of Canada.
Yeah. That's a more technical question. I would much rather leave to the JAG, the Judge Advocate General, to give you more details.
And same for outside Canada as well? Because there's two
outside
factors.
Canada is a different story, and Madame Arbour was very clear about that in terms of how we would proceed. And until the situation comes to ground, our MPs, our internal investigative organization structure would pursue the matter and bring it back to Canada and would be dealt with, again, through the local court system.
Thank you. And there have been problems with military officials not providing disclosure to civilian lawyers in a timely fashion in the past. Would you support an amendment to C-11 to prevent this from happening?
Certainly would like to hear more about it, because if that would help make it more robust, we're open to hearing more.
Thank you. And military police will not have jurisdiction inside Canada to investigate the crimes listed in C-11, but will retain jurisdiction outside Canada. Why would that be, if you could explain a little bit?
Well, because under international public law rules, we can't easily apply extraterritorial law from Canada, for example, in a situation like Latvia. And so we have to build a system which respects the fact that we have members of the armed forces living and serving abroad, for example.
Thank you.
So
And,
it's not an
Mr.
obvious thing.
Commissioned Worship, if I may, just a last quick
Yeah,
one.
you're over time.
Okay, thank you.
I apologize.
Thank you, Minister.
Thank
Chris
you.
Mallet, over to you. You have 5 minutes.
Thank you, You finished with 28?
The minister and I guess the deputy minister.
29.
As we've heard, Bill C-66.
Il faudrait qu'il ouvre son micro parce qu'il n'y a pas d'interprétation.
Pardon?
Il est ouvert son micro.
On me dit inaudible. Je pense qu'il vient d'être ouvert, mais au début, il n'avait pas.
Ah, okay.
The microphone wasn't on initially, now it is.
Ah, all right. Okay.
Merci.
You want me to start over?
Yeah.
Okay. All right, take it from the top, as the speaker says. Through you, Mr. Chair, to Minister McGuinty and Deputy Minister Beck, I would think. Bill C-66, as we've heard, started us down this path, and this is why this committee is now looking at the enhancements. Can we just delineate what exactly those enhancements and improvements and sort of the organic changes to the original, and what are the significant items that you would say would be highlighted in C11 as opposed to what was originally proposed in C66?
Yeah. The bills are not that distinguishable because they were considered to be appropriate. The balance had widespread support. All parties supported C66. But I'm very much open to, as we just heard from Mr. Kibble, open to suggestions for improvement from the committee. But it's a good, supported bill across Canadian society.
Okay. On another issue, then, some concerns have been expressed that victims will have to use civilian victim services when moving into the civilian realm for the prosecutions. Will the appointment of victim liaison officers material improve victim experience? And will the military support for victims or complainants in these cases travel into the civilian realm? Will they still have the same services, if you will, once the prosecution moves into the civilian realm?
Answer: yes. The victim liaison officers who will be receiving additional resources, getting more training, contemplated under this, making sure we're building psychologically safe and inclusive workplaces, for example. Not only that, but we're also amending access to VLOs, as they're called, for third parties who represent victims. Maybe that somebody who's a victim says, I don't really want to come out of my place right now. I'd rather have a third party act for me to get the assistance I need. So they can absolutely play a role with respect to the prosecutions and the investigations in civil society. The other thing to keep in mind is that we have a very, very well-established sexual misconduct support and resource center inside the department now, which is very much helping to strengthen support for survivors of sexual misconduct. So that body, the SMSRC, also now offers independent legal assistance and in-house counsel at no cost. It's also a needed improvement to give people comfort and give them the support that they need.
Just further and hand in glove with that, what guarantees are there that complainants will have access to the same amount of resources, especially around, as we discussed, mental health services, trauma-related resources as currently in place?
The Canadian Armed Forces is investing significantly going forward in mental health services at all 36, I believe it is, of our medical clinics. This is something that we're seized with. It is part and parcel of the need to invest in our people, to make sure they have the supports that they need, a place to go to, counselors to speak to, mental health advocates and experts. So this is part of the improvement we're making with the new reinvestment in the Canadian Armed Forces.
Okay. And again, our armed forces, as you said earlier, need to have a 21st century workplace. How will this bill have an overall cultural change, impact on the cultural change inside the CAF and on recruitment. If has that been at all considered as well?
It has. I think the two perhaps most important words objective here through C11 is to enhance trust and enhance transparency. We need to make sure that our Canadian Armed Forces is fit for purpose for the 21st century and fit for purpose for the women and men of the forces. It's very important to deal, as I said again last Friday to 500 individuals in a speech, it is time for us to expunge this behavior out of the Canadian Armed Forces. We need a high-performing force. They're high-performing now, and they're going to be needed to be even more high-performing going forward. And you can't have that. You cannot have that if you have lingering trust problems in the system. You cannot have that if there isn't a pathway, a predictable, transparent pathway to deal with this kind of conduct, which is exactly what we're trying to address.
Thank you, Minister. Thank you, Mr. Millet. Monsieur Savard-Tremblay, you have 2.5 minutes.
Merci. Alors, on va
Thank
parler.
you. I have two questions regarding the 60-day transition clause, the 60 days to transfer files to the civilian side. Have you reflected on how to make sure there will be no delays or issues with respecting to protection of the victims? And another question you can answer at the same time. With respect to those 60 days and transferring the files to the civilian justice system, people have denounced the fear of reprisal in the system now, and that there have been some measures of reprisal against people. What is there to protect these members? Two excellent questions. I can't fully answer the first. The Advocate General can answer the first one, if that's okay. I think we'll have some time with them after your appearance. I think that's if you can answer the second question at least, as to reprisals. Well, we'll have to see once this bill is passed, once the system is in place. We can't exactly predict what's to come, but if there are any recommendations from the committee to improve things or reduce the likelihood that there would be problems post-transfer, then we're open. We're all ears. Perfect. Well, we've taken note of it, and we'll see for the second part. Do I still have some time? Perhaps we haven't addressed this one aspect that is also interesting in the bill, the creation of the center, the support center. If I'm not mistaken, it's not something that's been discussed for a very long time, but it is an interesting service. How to guarantee that these services to victims are distinct from the military hierarchy? That reports, the Deputy Minister can remind, the Deputy Minister reminding me that that's something that falls within the Deputy Minister's purview, and Mr. Gravel is there, and he can certainly answer those questions. Look, go ahead. I think you'll be here in the second part. I mean, go ahead.
Donc, merci pour la question.
Thank you for the question. Indeed, given the change in Bill C11, there's been no change to support that is provided by the Sexual Misconduct Support and Resource Center, whether it be in the judicial system, in the legal system, in the civilian side system. The same supports will be available to victims. So the center's independence, its stability remains. The same services will be available.
We are now over to Ms. Gallant. You have 5 minutes.
Worship is considered sovereign territory. So if an incident happens on board in international waters, where does it fall in terms of jurisdiction? Who investigates and who tries?
My understanding is that it would be the Canadian Armed Forces, military police who would investigate, collect information, and then make a decision about how to proceed.
In Canadian waters?
Same thing.
So foreign territory and Canadian waters, the same thing.
Sorry, forgive me. No, I think in Canadian waters that matter would necessarily be transferred.
So on board a Canadian warship that's Canadian territory, the military police would have jurisdiction in both cases.
So this bill changes the appointments of key authorities such as the Provost Marshal, Director of Military Prosecutions, and Director of Defense Counsel Services in order to deal with undue influence. But what actions are being taken to ensure there is no political pressure, regardless of chain of command, and that this undue influence is not simply shifted to another authority?
That's an excellent question. And if Ms. Gallant, you see a way to improve that or make that more robust, we'd be certainly prepared to entertain it. I would be hard-pressed to believe that a Minister of National Defense would want to insert themselves in a prosecution of this kind. It's a legal matter. It's highly risky. It's illegal. It's unethical. It's against the ethics rules. And it may be, depending on the nature of that kind of involvement, subject to the criminal code itself.
What steps are being taken to guarantee access to witnesses, evidence, et cetera, for civilian investigations?
Forgive me, what? I'm sorry?
What steps are being taken to guarantee access to witnesses, evidence, et cetera, for civilian investigators?
Well, it would be illegal for...
And that's on base, Minister.
Pardon me?
And that's on base.
Yes. My understanding is that with C-11, this is basically an assignment of that responsibility and authority to police of local jurisdiction. So if there were a problem, for example, in Petawawa, whatever the local police jurisdiction would be there would have access virtually, I think, looking at council, unfettered access to the evidence, the information, and all that documentation would have to be surrendered.
Given the backlogs in the civilian justice system, what measures are in place to ensure victims are not simply transferred from one unjust system of cover-ups to one plagued with backlogs and delays?
Yeah, I don't know if I would agree with your characterization of a system of cover-ups. This is extremely serious business. The question of whether or not the provinces would be in a position to handle these prosecutions, these investigations through their police forces and their prosecutions, is one that we have been dialoguing with the provinces with for years. The MOU from Ontario indicates that it doesn't seem to be a problem in the making. We need to work together on this to make sure that we have a high-performing Canadian Armed Forces. And in my dialogue with provincial premiers like, for example, the Premier of Alberta recently, I'm reminding them on a regular basis the important role that our military plays not only for their safety and security, but for their economy.
How many victims did your office hear from when drafting this bill?
Does anyone have that number? Hundreds? Hundreds of victims? We can get you that number.
Okay. Rural communities often have limited budgets or lack staff. It's my understanding C-11 does not offer any funding to ameliorate this. Why not?
So, you're talking about investigative and prosecuting?
Correct.
No one's asked.
No one's asked.
And so it's an interesting reality. But remember, too, we have a constitution. You wouldn't be surprised if the federal government started inserting itself into public prosecutions or into prosecutions conducted by crowns that we may be criticized as meddling in different provincial affairs.
Do you think the bill adequately protects the privacy of the victim, either from media attention or harassment at work?
Yes, I do. I looked at that very carefully.
And what will the minister do for better security and other measures to reduce the sexual assaults, since really the transfer passes the buck to an external justice without addressing the internal issue? So the bill doesn't address the prevention of assaults.
There are many measures that are underway. Much change has been effected over the last several years. You're right to point out the need to make systemic changes in the system. The chief is, of course, not only just the CDS today, the chief of defense, but in a previous life was responsible for implementing most of those changes. She's best placed at this table to help you on that one.
Ms. Gallant, that was great. Okay. Thank you so much, Minister. I will give 5 minutes now to Mr. Tim Watron.
Thank you to the witnesses for being here. Thank you, Minister. I have a technical question. With respect to the military police investigations outside of the country, it is a change in culture for them, and I'd like to know whether they will be getting ongoing training for these kinds of investigations abroad and how they will then transfer those investigations back to Canada? The answer is yes. There will be professional development training and investments. And when you remove the responsibilities for these investigations from Canada, it means the military police are freed up to spend more time, have more expertise, and use more energy to focus on situations abroad. These are small numbers of circumstances that, at least from what I'm gathered over the last few years, small numbers. But again, the Judge Advocate General will be able to provide more details with respect to that. It's not only training. It might be professional experiences such as our medical surgery teams, trauma professionals also need training, and they need professional development to maintain that level when the time comes to use these skills in deployment. It would be fully open to the Provost Marshal General to make arrangements with police services on the civilian side to have those investigators there and to maintain their skills during these investigations. Thank you very much. Bill C-11 addresses the legislative side of Madame Arbour's recommendations. The Justice had 48 recommendations, actually. 30, and you deserve credit for this, have already been implemented, so 18 remain. And we're told that should happen by the end of 2025. I'd like to hear what you have to say about the 18 outstanding and which ones are your priorities over the next few months. Yes, Mr. Speaker, you're right. By the end of the year, this calendar year, we should have completely implemented all 48 recommendations. Out of 114, how many exactly, I cannot answer, but I will certainly get back to you as to the exact numbers. We are compiling these figures by the end of the year. Are there a couple, one or two, that are going to be a priority to your mind? Certainly, Arbor 5 is something that we're discussing here today. If legislation is passed, we could consider that Arbor is completed. Perfect. Members of the armed forces are anticipating these changes, certainly for the civilian system to be responsible for sex assault prosecution, specifically for women. Why is this a priority to have this bill passed so swiftly? It should be a priority for all political parties, for all members here around the committee in the House of Commons and all members of the Canadian Armed Forces. It's unacceptable to have a system where people go to work and fear for what might happen to them, or that there's no avenue for a solution before them. And that's precisely why we're pushing for the implementation of these changes as soon as possible. As I said, we're open to changes and recommendations to improve the bill. So much work has already been done in the system outside of the legislative changes that I find it encouraging. That said, we have no choice. We need Canadian forces that are serious, that are high-performing, and where people feel as though they can have confidence in the system. When I visit universities and colleges and I speak to young people who might be interested in joining, enlisting, often women, we have to be able to look them in the eye and say, hey, look, this is a system that is well managed, that is transparent, and if there were to be any problems, there are solutions. You will be protected. You can trust in the system. And further to that, another point is that we're calling on Canadians to support the Canadian Armed Forces fully. And this is something we're doing. We're investing in our Canadian Armed Forces. And Canadians want to know that the system is well managed, that these types of problems from the past have been resolved or being addressed within the Canadian Armed Forces.
Watchhorn. I will now pass it over to Mr. Anderson. You have 5 minutes.
Thank you. Many victims don't report instances of sexual assault to protect themselves. What does this bill do to alleviate that?
We hope that the bill will add to the changes, Mr. Anderson, that have been made inside the department to give victims confidence that they can trust the system, they'll be protected, that there's a transparent pathway, and that it's serious.
With cases going to civilian courts, what safeguards would this bill have to ensure that media reporting on the situation does not present an opportunity to dismiss important evidence at trial?
I'm not sure if I foresee that in terms of the rollout of what might occur. I don't know if our JAG can give me 1 line or 2 lines on that.
So,
Appreciate it.
Thank you.
I don't contemplate that. Frankly, it may be. I don't know. We'll see what happens with the transfer system. But remember also that Crowns and defense attorneys can ask for publication bans. It's a part of the criminal system.
Okay. C11 indicates that sexual offenses will be transferred to civilian court. Will those offenses be tried under criminal code and or service code of discipline?
My understanding is they'll be under the criminal code.
Under the criminal code, okay.
Just like any other Canadian who's got a case to bring, to be investigated.
Okay, so there won't be any overlap then?
Nope.
Okay. Will all sexual offenses be transferred to civilian court or just some?
All criminal code sexual offenses will be transferred.
All criminal code?
All criminal code sexual offenses.
Regardless of seriousness?
All criminal code sexual
Gotcha.
offenses.
For cases not transferred, why not? Where's the cutoff? Oh, sorry, never mind. No. That was if you had answered a different way. How will cases that are found to be not a criminal code offense be transferred back to the military so that investigation and discipline can still take place under the code of discipline?
If the matter is not adjudged to be a criminal code sexual offense, it will remain inside the military.
So it would never have been transferred over in the middle?
Not if it's not a criminal code sexual offense.
Okay. C11 transfers these cases to civilian justice system because of the failures of the military justice system. Are there plans to make changes to the military justice system to achieve the required standards and eliminate conflict of interest for these deployments
That's a really
overseas?
Very, very important question and a good one. And I'm very open to hearing more from you, particularly with your own background, to see how we can get that right, get that improved. We have the JAG here who manages the system. We've made some progress, but we're very open to recommendations.
Okay. Will those changes be effective in ensuring, never mind, if we can effectively make those changes for cases abroad, why can't those changes be made through the Canadian Forces justice system such that all prosecutions, investigations, etc., are conducted by the military justice system properly, whether in Canada or abroad?
Forgive me, I didn't catch the question.
If we can effectively make those changes for cases abroad, right now it goes to the military justice system, why can these changes not be made throughout the forces right now so that regardless of whether it's domestic or foreign, they can be heard by the military justice system? In other words, if justice is not good enough here in Canada through the military, why is it okay over there?
Oh, it's a question of, I think, of fundamentally of international public law. It's where you're situated, right? You can't necessarily just apply Canadian law extraterritorially. If you have a situation, again, for example, let's say theoretically there's
forgive me, but understand that that's not really the question. The question is if we are going to rely on the Canadian justice system abroad, why can we not make those changes domestically to make it work here as well?
Well, we would be relying on the military police abroad and the defense justice system abroad. And if there were an occurrence abroad, it would be investigated and brought to Canadian courts.
Okay. If we can effectively make those changes, what kind of cooperative communication regime will be set up to communicate between civilian police, military police, and the command structure of the CAF once an accused is turned over to civilian jurisdiction?
Started. These prosecutions began as far back as 2021. Many of them have already been into the civilian court system. And so there's a very well-established sharing of information and understanding through 2 qualified police forces.
Okay. For instance, there was an incident in my own hometown where 2, the accused and accusers were both sent home on the same bus. And the reason was no communication from the civilians once it was turned over to the civilians. So I'm wondering, in a case where a serving member is still on base and accused, and there's no communication from the civilian police force, what structure, what is the commanding officer on that base supposed to do with the accused?
Again, a very specific but important question. I haven't given that much thought in terms of the mechanics of this. I'm not sure if anybody here at the table can add anything to that. Can you, quickly?
So the same protective mechanisms that are available in the military justice system under the Declaration of Victims' Rights are available to prosecutors, judges, actors in the civilian justice system. So there can be no communication orders made by civilian authorities within the system, but certainly within the military, as proper maintenance of good order and discipline within the military, there's the ability of commanding officers to direct that members not communicate with each other and to make work arrangements to ensure that they are not together. The challenge, as you identify it, is ensuring that there's an awareness on the part of the commanding officer of the situation.
Thank you. Sorry, we're over quite a bit, and I am sensitive to time. Ms. Sherry Doronado, you have the last go, please.
And through you, I'd like to thank the witnesses for being here. This is a tough subject for me. Justice Arbour indicated in a press conference in May 2022 that, and I quote, "Criminal sexual offenses should be within the exclusive jurisdiction of the civilian criminal court. This was the case prior to 1998. Military justice rests on the need to enhance efficiency, discipline, and morale in the armed forces. No other rationale was advanced in 1998 to vest jurisdiction in the military system for sexual offenses, which until then had been within the exclusive purview of the civilian court as murder today. The handling of sexual offenses by military court in the past 20 years has done very little to improve efficiency, discipline, and morale. If anything, it has served to erode it. Therefore, I see no basis for the Canadian Armed Forces to retain any jurisdiction over sexual offenses, and that jurisdiction should be vested exclusively with civilian authorities." Minister, when I hear and I review that statement, I think it's very simple. We don't investigate and prosecute ourselves. And I think to myself, how many victims have not come forward out of fear of reprisal? How many actually suffered in silence? And how many actually left the Canadian Armed Forces with that trauma and they still suffer today, who may be watching today and saying, maybe finally I will get my shot at justice. As you know, I'm a family member, and I speak to families all the time, whether it be people who have family members serving or people who have family members considering joining. And when my kids first started out, it was always about the job, the dangers they put themselves into. But over the last couple of years, it's always about the culture. It's about the change of culture. If you had some time to speak to victims today and their families, what would you say about what we're trying to do here with C-11 and the importance?
I would say, based on what I've read and heard, the conversations I've had with victims, that I'm heartbroken, that it's taken decades to realize we have to do something fundamental and foundational in making changes. I would say that we've listened. I would say that we're making legal and regulatory and structural changes inside the Canadian Armed Forces to expunge this kind of behavior. I would say that they are heroes for putting up with this and for suffering in silence. I would encourage those who are listening who may want to come forward to come forward. That's why I opened my comments this morning with a toll-free 24/7 phone number for folks to call for any victims, potential victims, anybody who is hurting. I would say that it's a foolish armed forces that does not want to avail itself of all the talent it has by allowing a culture problem to fester. And what we're doing here is to ferret this out, and we are putting in place structures that will allow us to go forward. There's such talent such talent, such dedication, such values in the Canadian Armed Forces, such good people. We need to make sure that we get rid of extremism and hateful conduct and ferret out applicants. And we've changed the rules around, for example, how we screen applicants. We've changed probationary periods because we want to make sure that we have the right people. We're investing for Canada. Canadians are asking us to improve the situation. They're sending us a lot of revenues and saying, please get this better. So I would say for those folks, particularly the women, a lot of women, men, women, who are quietly asking, why did this happen for so long? We're moving forward. We're building on your standing on your shoulders, and we thank you. We thank you so much for sticking with us and allowing us to make these changes.
And thank you, Minister. Thank you, Ms. Raminato. In speaking with some of the victims this morning, in fact, one of them brought up the fact that there is a best practice that exists in the military that they suggest we adopt in the civilian side, and that's the pre-charge screening, a model by which they found useful in assessing the viability of their prosecution in terms of its success to move forward. And if it does proceed that way, they feel that all civilian cases should go through that screening process the military does now. Minister, thank you. I'm going to recess, ladies and gentlemen, for a changeover for the next half. General Carignan is not going to do her 5 minutes. She's asked us to proceed directly into questions. So thank you for that. And I'm going to start us off with Mr. Anderson, you have 5 minutes. We're going to do 5 minutes all around for each one. Okay?
Sounds good. Thank you very much. I would like to return to the communication between police forces, if I may. That's more of a technical question, and it's not covered in C11. Can you explain how this would be dealt with?
Mr. Chair, thank you for the question. Police corps do consistently communicate and coordinate their activities together. So for access to a base for the needs of investigations, they speak and they enable their access to everything that the civilian police would need to conduct their investigation. So we have done this regularly in the past with other type of charges and allegations, and of course this would apply to the same system would apply for this type of charges.
And just to return to the bill specifically says that military police cannot collect evidence. So I'm wondering, how do you deal with that, Mr. Holm?
So I may be getting ahead of clause by clause, Mr. Chair, but there actually are provisions in Clause 8 that deal with the ability of the military police to collect and preserve evidence while they're waiting for or before they transfer. So there's an immediate responsibility, even within Canada, for the military police. That's found in Clause 8 of the bill.
Thank you. Since December 21st, criminal offenses of a sexual nature have been transferred to civilian authority. Do you have data on how many cases? I think we're going to move that one over.
So I have some data that I can share with respect to the number of cases tried in civilian courts since that time. I also have data with respect to the 5 years leading up to the implementation of the interim.
Okay.
And so in those 5 years, on average, 300 to 350 investigations conducted by the military police in that time, and a total of 44 prosecutions. So an average of about 9 a year in those 5 years. Since then, the numbers I have with respect to prosecutions are in fiscal year 22-23, 13 prosecutions of what are the sort of offenses that are in the bill now, and 7 in 23-24. This is as you're seeing the sort of implementation of the Director of Military Prosecutions directive that he would no longer prosecute any cases within the military justice system. And so there's a ramping down. That said, there are 4 cases that remain to be tried in the military justice system. Those charges were all charges that were stayed several years ago. Those stays were lifted by the Supreme Court of Canada in a decision last year. So this is getting back to completing those cases within the military justice system.
Perfect. Have any cases been thrown out due to the Jordan framework?
I know only of those ones that are in the news. There was one in Pembroke that was fairly notorious that had, with the victim's request, been removed from the military justice system, transferred to the civilian justice system, and the judge found that the 9 months, that had proceeded in the military justice system counted against the jeopardy for the accused, added them to the Jordan framework, and stayed the case. I'm not aware of any others.
Okay. Does the Victims' Bill of Rights present any concerns for the ability to pass information back and forth between the military and civilian systems?
So the Victims' Bill of Rights is mirrored by the Declaration of Victims' Rights within the military justice system. So the same provisions apply back and forth. It doesn't provide very much in terms of sharing of information. It's mostly about the rights of victims to access information about their own case and about people involved in their case. But it doesn't impose an impediment to the sharing of information, no.
Okay. What actions will be taken by the CAF by the CAF to ensure victims are protected within their workplaces as things are being adjudicated by the civilian? And this has, of course, to do with communication as well.
So this is, I think, consistent with the answer that I gave you in the last round, and the Chief and CPCC may wish to talk about that as the actual commanders at the table.
Okay.
So currently, the chain of command is dealing with the sexual misconduct and sexual assault cases in various ways, depending on what they are facing. So victims keep agency over their own situation, and the chain of command does respond to that, depending on the victim's wish in dealing with their own cases. So the chain of command, there's been training ongoing to ensure that we dealt in an appropriate manner with all victims and all cases, how it's reported, what to do with the information, guiding the victims towards the support that they need at the SMSRC, providing all types of, again, depending on the level of support that the victim is requiring, and ensuring also the safety of the victims as the cases are being reported.
Thank you, General. Thank you. Ms. Vivian Lapointe, you have 5 minutes.
Start with 5.
We know that culture change within the Canadian Armed Forces has been a central focus of your leadership. How does Bill C-11 align with the work that is already underway to build a more inclusive and a respectful culture across the forces?
So the bill allows for more clarity of jurisdiction for victims. So there is one clear path, and it is via the civilian system. So there is no more gray zones, and this is what Madame Arbour was going after in her recommendation 5. And also the demonstration that it was independent from the chain of command. So providing that independence, transparency, but also a clarity of jurisdiction. So there can't be any questions as to what is the correct path through justice.
The legislation formalizes the victim liaison officer role, and it also enhances supports for those affected by misconduct. How do you see these new supports complementing the work of the Sexual Misconduct Support and Resource Center and the efforts already underway within the forces to improve survivor care?
So this is part of the how victims are accompanied during their path to justice, ensuring that they have the appropriate support to navigate the justice system and getting the appropriate level of support as they go through this path.
As the forces transition to this new framework, training and awareness will be very important. Could you speak to how Canadian Armed Force members will be supported and how they'll be prepared to understand and implement the changes that are being introduced through Bill C-11?
So every time we introduce new legislations or changes, we also ensure that appropriate training is delivered to our members to understand the differences. So this is going to affect a number of organizations or individuals as part of this transition, and communication and again ensuring that people have the appropriate training to ensure that this is the transition is affected in a positive way.
Now, sustaining progress over time is key to ensuring that culture change takes root. How does the implementation of Bill C-11 fit into the longer-term effort to make the Canadian Armed Forces a safe and inclusive and trusted organizations for those who serve?
I think what is most important is as we introduce changes, whether it's new legislations or new initiatives, we want to make sure that we actually measure the effects and impacts of those changes. So we have designed a structure, processes, and a full organization that can do that in ensuring that those changes have actually the effect that we are anticipating or that the intention behind the introduced change. So we're going to be measuring the impact of this and ensuring that this is actually meeting the intent.
And embedding reforms like those in Bill C-11 directly into law sends a clear signal of lasting commitment. From your perspective as Chief of the Defense Staff, how does that kind of legislation action help strengthen confidence and trust across the forces, though?
I think this is mostly related to ensuring independence of the process, ensuring that victims are enabled and that they keep agency over their own a process and how they want to go about their own complaint. So it's about providing them an approach that respects the agency that they have over their own process and ensuring full independence of the justice process that they have undertaken.
Thank you, General. I'll now go to Monsieur Savard, Tremblay. You have 2.5 minutes.
2 minutes et demie.
2.5 minutes. Well, 5 minutes, okay. So I won't ask the same question as last time. I'll give you an opportunity to answer it directly. So that's 60 days to make sure that there are no delays?
Je sais pas si ça va être plutôt du côté.
I'm not sure if it's on the JAG's side. The Provost Marshal can answer the question. We are planning the stages to shorten that transition period. It's 60 days following royal assent. I'm not sure how to say that in French. We'll ask the interpreters.
Sanction royale.
Sanction royale.
C'est ça.
Royal assent. So 60 days after royal assent, jurisdiction is lost. There's a section that provides for another 60 days to finalize transfer. So that 120 days total period is enough to ensure that the victims have what they need within the civilian system. How to make sure that there are no delays within that system? Well, it's not within the bill, but as the Chief of Defense Staff said, that's part of our weekly communications, actually daily communications between the civilian police and military police to make sure nothing falls between the cracks. Are you saying both weekly, or on what basis were you saying? Based on my understanding, there is this discussion between the two police forces. The police forces on the bases are always in touch with the civilian forces, the police of jurisdiction outside the base. Okay, so maybe I can broaden the question a little bit. All of this will be quite an issue with respect to coordinating all of these forces. You've got the police and the provincial forces, you've got the military forces, you've got the department. There are many, many actors. Is that already in the plan? Has that been really thought out? There's that legal coordination, but there's also a financial side to it. Is all of that already provided for? That coordination currently exists between those police forces. There are ongoing discussions between the police forces as to matters of jurisdiction in various cases. Depending on the allegations, it could be the RCMP. At times, it can be municipal police forces. Sometimes it can be the provincial police forces, and all depends on the case. At this point, that coordination already exists. So it'll be about anticipating things now. The police forces are expecting this now. It's been a few months and actually a few years that this process has been underway. So once the legislation is passed, then just have to simply move to the next stage. I would imagine my time is up. Right, 5 minutes. Sorry, I forgot. That's why I've been stressed from the start of my questioning. Okay, another question. Can we expect to see some statistics to see how effective this bill is and the act, and the changes with respect to the complaints, the transfer to the civilian side, the rates of charges, convictions, the degree of satisfaction among victims, all of that? Can we expect it? Yes, we certainly can expect that. In fact, between the professional misconduct and culture chief and the SMSRC, there is data is being compiled to follow up on the effects of the various changes afoot. So, given the number of complaints we receive, where things stand all the way to the courts processes, and also the trials underway will be monitored as well, because as soon as the armed forces member is involved, then we have to follow up administratively as to the person's career today and as to a future in the forces. So based on what I'm hearing, anything that affects the members, yes, correct. So I'm wondering, what are the factors that will allow us to assess the actual... Sorry, am I disturbing anyone here?
En fait, j'ai pas eu le temps de l'affiner. J'avais l'impression de déranger mes collègues.
Sorry, I was hearing my colleagues while I was asking the question. If they're uninterested, then, perhaps they could have their conversation outside. Now, my question is, the Arbor report was talking about a culture of impunity. So is there some assurance? I mean, what will we have? Apart from the statistics you're referring to, are there going to be reports? I know for the public, you internally, you do your own checks and et cetera, but we parliamentarians or the public in general, will all of us have access to this information? Go ahead. We'd certainly be in a position to do this. There are a number of reports. Martin at the Resource Census produces reports. The JAG also, we produce reports that are public. Now, with respect to culture and misconduct, we also have the CCPC, which I don't have the translation for. That's within the public domain. We publish data and incident reports. Nope, nothing is private there, but you can follow how things proceed through the system. We're starting to work more in depth on the data side. We have a lot of data, but there's some consistency issues. We address the problem first off, and now we have to look at how we'll want to measure these things.
Merci. Thank you, Monsieur. Ms. Gallant, you have 5 minutes.
Police need more training and experience investigating sexual crimes. Because if they're going to manage investigations outside of Canada, we need to know what the plan is to keep them trained and sharp.
So as we speak now, the military police has been ongoing specialized training to interview victims and deal with sexual assault cases. So they have been trained over the past few years, but the question probably would be better answered by the Provost Marshal. But they have been undergoing training, and this is part of what they do as they tackle sexual assault cases.
How much money does Defense Counsel Services spend annually providing legal services to CAF members accused of criminal sexual offenses?
So I don't have the answer at my fingertips. I provide them with 7 full-time regular force legal officers along with the director. But the director also has the ability to contract civilian lawyers that he uses in particular circumstances. So I will take that on notice and get you the answer.
Can you elaborate on the transfer process section of the bill? Specifically, how does the transfer of a detained person to the civilian authority take place, as well as the procedure for the collection of evidence?
So in the vast majority of the cases, members are not detained at the beginning of an investigation. So when a complaint comes to the military police, a complainant comes to the military police, they start their investigation under the interim policy that the CFPM has put in place. If the individual wishes to have the matter dealt with in the civilian system, they transfer it then, and the investigation is done by the civilian police. In any case, even cases where the military police are doing investigation today, the charges are laid in the civilian system. So if there are any arrest warrants that need to be carried out or served, they would be done within the civilian system, and custody would be reviewed within the civilian system, not the military system.
So what training and dollars associated with this training would go towards preserving the chain of evidence and the investigations?
So again, we'll take it on notice. Certainly, part of the military police training at the Military Police Academy has to do with the collection and preservation of evidence and ensuring the proper trail of custody of the evidence before it is turned over. But we'll find out how many resources they put into that training.
So victims have expressed concerns with the cross-pollination, the sharing of information between the civilian and military systems. There have been cases where prosecutors and local civilian law enforcement bodies have passed on information to military ranks to quash or weaken the cases of victims. So what measures are in place to prevent this from happening in the future?
Information coming from civilian authorities back to military authorities?
Yes.
Okay. So privacy acts that are applicable in the provinces and territories are the primary piece of legislation that deals with the sharing of that information. I'm not aware of any particular cases of the sort that you describe, but I imagine that they would be completely inconsistent with the privacy acts or the privacy-related legislation of the provinces and territories.
What specific training will civilian prosecutors and defense counsel undergo to account for the difference in culture when taking on these cases? So military to civilian.
So I can certainly speak to the prosecution side of this, less so to the military police side. The Director of Military Prosecutions is part of the Federal, Provincial, Territorial Heads of Prosecution Services Committee, which has a number of subcommittees as part of it. Through that mechanism, there's a constant interchange and sharing of information with respect to the importance of the military justice system for discipline, efficiency, morale, those sort of issues. And in fact, in recent years, pursuant to a FISH recommendation, they've come up with a set of presumptions and principles that are publicly available, dealing with how to deal with concurrent jurisdiction between the two systems.
Regarding the collection of evidence portion of the bill, how would the legislation affect the distribution of rape kits to victims?
So they're not generally distributed to victims. They are used in hospitals by medical professionals to collect evidence. When that evidence is collected, once this bill is in place, that's not evidence collection by the military police. That would be evidence collection that would be turned over to the civilian police.
Thank you, Major General. Thank you, Ms. Gallant. Passing it over to Mr. Chris Mella. You have 5 minutes.
Thank you, Chair. I'm going to stay with the victim support angle here. Bill C-11 proposes to transfer jurisdiction over sexual offenses committed by CAF members in Canada from the CAF to the civilian justice system that we've heard at length, expand access to victim liaison officers, and introduce enhanced protections for victims. What measures would be put in place to ensure that victims are supported during the transition of cases from military to civilian jurisdiction? To anybody who could answer. General Carignan? Or Monsieur Gravel? Sure.
Yes, absolutely. Thank you for the question, Mr. Chair. As I mentioned before, from the SMSRC's perspective, the supports and resources that we currently offer will continue regardless of the transfer to civilian justice system. In fact, I'll say that a lot of the clients that we serve right now, some of them are actually being dealt with under the civilian justice system already. One that we talked about earlier is the Independent Legal Assistance Program. Already since May that we're in our phase 2 with our internal lawyer, we've had 34 clients, some of which include people that are going through cases in the civilian justice system already. So we're well set up to continue with the same supports and resources.
Further to that, what role would victim liaison officers have in improving communications and trust between victims and the military justice system?
I'll transfer it to my colleague at CPCC to speak more to the VLO program.
Yeah, so on the VLO program, what this legislation brings is it allows somebody to ask for a VLO on behalf of a victim. So that is the change with this legislation. The victim liaison officers are there to provide support to victims when respondents are, or where a respondent is accused of a service offense. So if this moves in, right now we're discussing how we're going to expand the program because our VLOs are really well versed into the military justice system and not the civilian justice system. So we're looking at how we're going to expand that program and how do we do that interface with all those services that are available in the civilian justice system as well.
Do I have some time? Okay. Further to that, then, Monsieur or General Prévost, there's been some concern we've heard from victims who now will have to rely on, and I think it's a bit of a patchwork quilt across the country of what sort of victim services are in place in the civilian realm. I know in my own riding in Bay Quinte, the City of Belleville Police, for instance, just onboarded and hired a victim services person full-time. That's not the case in all areas. So I guess there is some reticence from some victims who say they're not convinced that maybe the transition or those supports will be there for them when they take their case to the civilian system. What reassurances can we give them on that? General Carignan? Yeah, sure.
Yes, from our perspective, like all of our public service employees and CAF members have access to SMSRC support. So this is a firm support that exists regardless where they are in Canada. So regardless of which jurisdiction will prosecute the case, the SMSRC will remain as the firm support for victims.
Encouraging, thank you. Now, to General Holman or Ms. Beck, in addition to proposing to transfer jurisdiction over sexual offenses committed by CAF members from the CAF to civilian justice system, Bill C-11 would introduce structural reforms to the military justice system that are aimed at improving procedural fairness and victim engagement throughout the complaint and hearing process. How would the proposed structural reforms, including changes to hearing procedures, ensure that victims are better informed, supported, and able to participate meaningfully in the proceedings involving service officers, to whomever?
So perhaps Jag can add afterwards, but to be clear, the 24/7 line that currently exists is there available for victims all across the country and their families. And now, of course, the Coast Guard has access to our particular systems. We also have a well-resourced response and support coordination program that is there to help interpret, in fact, to accompany the victims through the processes, providing support, advocacy, and personalized case management. So all of that will continue.
Thank you, Deputy Minister. Appreciate that. Monsieur Savard-Tremblay, you now have 2.5 minutes.
Merci. Pour continuer.
Thank you. Let's keep going with the issue of coordinating all of these things. You were saying nothing new really is envisaged under this bill. There's another aspect that I was wondering about. There's still the option for military involvement for the conservation of evidence. And how do we make sure and then again, that there wouldn't be intrusion in on the civilian side, or encroachment. Well, the military police is well informed about their jurisdiction and their role to play. It will be on a case-by-case basis. You could end up with a situation that's an emergency. You immediately have to do something for the security of the victim, and that police officers can do so that military police can do that until the time comes to transfer jurisdiction to civilian police forces. In some cases, victims may wait a few months before laying any kind of complaint, and they will see how they want to report on these events. The SMSRC is in a good position to inform victims as to what route to take. Take, for example, a victim who decides to go straight to civilian police forces without discussing anything within the chain of command. That's completely in line with what I was saying about victims having full control about the way in which they want to manage their complaint. That's what I mean. And that is something that we defend. And the victim can also choose to go to the chain of command, and the chain of command can take decisive action to make sure that the victim is safe. So there are a number of scenarios that are open to victims. Again, to make sure that the victim is fully in charge. I would imagine
I will now pass it over to Mr. Kimball. 5 minutes.
Thank you, Mr. Chair. Before you start your time, just for the record, it's Kibble, not Kimball. No M in there. Just
my apologies.
No, all good. Thank you.
You're not the first person I've ruined by way of their last names.
You've certainly not ruined me. I think I can recover. And thank you, Mr. Chair, through you to the panel. I just want to circle back to Canadian Warship being a sovereign platform. And you mentioned it was discussed that both in international and Canadian territorial waters, prosecutions would be under the military justice system. What about when that ship is alongside, say, the Port of Vancouver?
So alongside the Port of Vancouver, I think without question, it's in Canada. So the military police would have the authority to take those initial steps that are dealt with in Clause 8, but thereafter it would be the civilian police that would take over.
But in international water, it would...
So that's an interesting one that I think I'll take on notice, and we'll come back to you by the time we get to clause by clause.
Say at anchor, right? So that's,
yeah, I know.
So there's just some areas that need some definitions,
and I had it going through my head after the initial question, and I think I understand the question now, and we'll have a better answer.
I think
when
that
we
needs
get to clause by
a
clause.
much closer look at to define what would be best for
you.
everyone in question. And a follow on to that, I know the Coast Guard is currently preparing to deploy, or already is deploying with the Navy in the Arctic in Canadian territorial waters. Will the military justice system apply to the Coast Guard now that they're under and reporting to Department of National Defense?
The answer is no.
Thank
They
you.
are not members of the Canadian Forces.
Sorry, they are not?
They are not members of the Canadian Forces, so they may have it applied to them if they deploy, for instance, as people accompanying the Canadian Forces in that small sort of case, but not presumptively.
Thank you. And what mechanisms does the bill have in place to prevent a liaison officer from being a friend of the accused? The CF used to use retired and active members in court to liaise.
So for VLOs, the provision that's in there right now says that if unless it's impossible for operational reasons, commanding officer who's requested to appoint a VLO should appoint the person selected by the complainant. And so that's the one mechanism that exists right now to ensure that
will continue.
Correct. That'll continue to be part of the
Thank you.
Of the law.
There's no provision that prevents the VLO to be a friend of the member, but the VLO cannot be party, witness to the case.
Okay, thank you. C11 says that military police cannot investigate. What does this mean exactly, given the military police will most likely be the first responders on any in-base local incident?
So I'd refer you again, Mr. Chair, to Clause 8 of the bill, which actually provides three specific provisions of carve-outs of what the military police would be allowed to do that is not investigation.
So would they be allowed to secure evidence, for example?
Yes, they would.
And would they be allowed to take statements?
I'd have to refer to the bill itself, which they can do anything to the extent necessary to prevent the commission continuing a repetition, including making arrests. They can secure, preserve any evidence related to the offense.
Did that include statements?
It's not explicit in the bill as I am looking at it here.
Okay, so that might need revisiting as to what's the best method forward for statements. How will the military ensure the accused has adequate representation? Court-appointed lawyers don't necessarily have the same understanding and of military culture.
This is an issue that Madame Arbour recognized herself, but what she also recognized is concurrent jurisdiction, particularly over criminal code offenses, has always existed in Canada, with the exception of murder, manslaughter, and child abduction. So it's been a feature of that dual concurrent system that that the structure for provision of defense counsel services is only provided to folks who are dealt with in the military justice system. So at this point, there is no plan. The bill does not provide for the provision of defense counsel services to individuals where the charges proceed outside of the military justice system.
Thank you. And will accused members face internal administrative action while the case is ongoing in civilian courts, and who decides what that internal action should be while it's still a determination of guilt or innocence is being determined?
Yes, so thank you for the question. So administrative process can continue in parallel to the disciplinary process or the justice system, and it's up to the commanding officer of the unit or, in certain cases, to the formation to deal with those administrative measures.
It'll be each CO will have their own determination. It seems that do you feel that that would be a bit of a patchwork of arbitrary justice going forward?
In parallel to the justice system.
But each commanding officer would have a decision over internal administrative actions.
Correct.
Okay. How will the Canadian Armed Forces maintain training and ability to prosecute cases overseas if it has no way to practice it here in reduced caseload as they're being transferred to civilian?
So the Director of Military Prosecutions has a very extensive training budget that can and will be used to undergo, to have prosecutors undergo training. Also, similar to my response with respect to the military police to one of your colleagues, the opportunity exists to second military prosecutors outside the prosecution service. But maybe the most important one, I would say, is we have some very experienced reserve force prosecutors within the Director of Military Prosecutions whose full-time day job for the Ontario Crown, for example, is as sexual assault prosecutors. And they are both available to prosecute, but also to train and mentor military prosecutors.
Thank you, Major General, and thank you, Mr. Kimball. Thank you. Mr. Kibble.
Kibble, no M.
Kibble.
Same as dog food, no M.
Yeah.
Doggy food.
Watchhorn, I think is pronounced correctly. Over to you. You got 5 minutes.
Merci, monsieur.
Merci à vous.
Thank you. I'd ask the panel as a whole this question. Let's take the perspective of victims. Every case is different, but I'd like to know how a victim deals with things. Okay, first of all, there's a complaint. Something has happened. There's been sexual assault that she claims there's been sexual assault. How does she proceed? And how does C11 improve the whole process?
Commencer, premièrement, la victime a plusieurs...
First, the victim can come forward in a number of ways if she trusts the chain of command. And in fact, statistics seem to be showing that victims have greater trust in the process, even though there's still some issues. But they can turn to the chain of command. They can also go through the SMSRC. we also have 16 centers within the country where people can bring forward these charges. If it's a criminal offense, then the victim can be accompanied also on the civilian side. As a follow-up, I'd like to understand how this works with the victim liaison officer. How did they interact with the victims and with the court? Thank you for the question, Mr. Chair. I'll defer to my colleague for the liaison officer side of things. But within the center, if a victim contacts us to discuss an incident, something happened, the first thing we want to do is provide tools for this person to take the most informed decision. And that includes the option to have a victim liaison officer with them. What does that look like? And the intent is really to inform the person so this person can make his or her own decision as to the path ahead. Provost General, with respect to liaison officers, as I think I mentioned earlier to your colleague, there are 136 liaison officers in the forces, and they've accompanied people through several cases with our members. They have a very trauma-informed approach, and the program aims to accompany victims through the military justice system. Now, with Bill C-11, sexual assault cases are removed from the military justice system and now transferred to the civilian justice system. And we are now looking at what to do with our liaison program, because the system is very different. Our liaison officers are trained within the military justice system, and that's distinct, very different. So how do we help? Do we simply transfer services because civilian side courts have support for victims? Do we just do that transfer? We're looking at that. We're looking at that question. And if I can add just one thing, what the bill would bring as an additional benefit is that the liaison officer program is not just for the victim, but for any person that the victim appoints. Okay, so a victim could appoint a loved one or another person to interact with the victim liaison officer? Correct. Perfect. Do I still have time? 1 minute? Okay. In the bill, we hear about structural reforms with respect to hearings. Are there any changes to procedures at the hearings that would mean victims would be better informed, better supported, so they could significantly take part in any procedures with respect to military justice, the military justice system? Look, I'm not 100% clear on the question, nor even Mr. Malet's question earlier. The hearings for sexual assault cases are now under the civilian courts and not the military courts. So perhaps one of the improvements or benefits of this bill is that it grants victims some certainty, that is, the complainants also some certainty as to what justice system, what police forces will be investigating. And the hearing will happen in the civilian side. Thank you very much. Thank you, Mr. Chair.
Mr. Bazan, you have 5 minutes.
Thank you. Always gets money right. One of the few. So thank you again for all the witnesses for being here, and thank you for your service to Canada. General Provo, as the Chief of Professional Conduct and Culture, I understand that you have a stakeholder group that you will consult with from time to time that are more, veterans and civilians and that. Did you consult with them on Bill C-11?
I did not consult with them on C-11. I was not involved in Bill C-66 at the time, but Madame Arbeau did extensively discuss with victims, and as Bill 66 was crafted, victims were consulted.
Okay, thank you. The minister said that he had no clue why he has been given the power to intervene on cases, giving ministerial directions, a power that lies right now with the JAG. And as the JAG, you're losing oversight, or you no longer will have the director of military prosecutions reporting to you, since they'll report to the ministry. You'll no longer have the director of defense counsel services reporting to you, since they'll report to the minister, and you're losing the power to give direction on prosecutions. So the minister is saying he doesn't know why he's been given these powers, and so I'd like to kind of get an idea where this is coming from.
Sure. Well, to start with, both the DMP and the DDCS will remain under the JAG's general supervision and will be subject to general instructions in respect of how they do their duties and functions. So the change that's being made is in respect of the Director of Military Prosecutions, where it will be the minister who will have the authority to give case-specific instructions to the DMP. So that was a recommendation of Justice Fish, and Justice Fish based it on drawing the analogy of the Director of Public Prosecutions of the Public Prosecution Service of Canada and the Attorney General. And so effectively, the minister now sits in the role of the Attorney General in respect of giving case-specific instructions. I will say that, like the case currently with the JAG, any specific instructions given by the minister are presumptively public, and so there would be transparency, as there would be in the event I ever used the authority to make those instructions.
Okay. Flipping through Bill C-11 here, and we talked a lot about that, civilian courts and police agencies will, of course, be potentially collecting evidence or get it from the military police. I don't see in Bill C-11, though, where access is granted to municipal police agencies, provincial police departments, or even the RCMP. Do they get access under the National Defense Act today onto base?
So they do
have
now.
To get permission?
Yeah. So they are given access when they need access to conduct investigations today, and that access would continue.
Who makes that decision?
So the local base commander has the authority.
So the base
to make
commander
that
could
decision.
deny them access to the base if he doesn't believe that they have a case to come forward on to investigate.
There would have to be a rationale for doing so
Protecting a
that
friend.
would outweigh the benefit to the public of having the investigation done. And certainly the the civilian police, if they felt like they were being interfered with, would have a number of mechanisms to deal with that, including
Should we
going up
not
the chain.
be defining that in the Act then, that if we're no longer going to provide, or not allow military police and National Investigative Service to actually do any of the investigation, shouldn't we be making sure that within the Act that there is access granted for all requests immediately as defined by legislation rather than at the discretion of a base commander?
So I leave that to the wisdom of Parliament. What I would say is, with concurrent jurisdiction now, the Act is silent, and the civilian justice system has access as required. Even where there is sole jurisdiction over murder, manslaughter, child abduction offenses, I'm not aware that there have been any problems with the military police having access.
Military police, you said. I'm talking civilian.
Sorry, you're right. Civilian police
Okay.
is what I meant. I apologize.
Now, we did talk about, everything's going through the civilian system and potential administrative measures taken. But if somebody is found guilty in the civilian system, sexual offenses, wouldn't that also automatically trigger a court-martial?
But it would certainly give clear ability to release someone from the Canadian Forces under the release provisions dealing with misconduct.
Okay. So,
Thank you. Thank you, Mr.
Point of
President.
order,
Yes,
Chairman.
Ms. Schick,
So I think I was maybe perhaps being too polite and oblique when I was asking the question about the rape kits. So specifically, I wonder if you could reply in writing as to how we can ensure that victims, if they're on exercise or if their base does not have a hospital, how the evidence can be preserved by getting the procedure done as soon as possible. How is that going to happen?
You bring that and perform that in writing? Thank you, Deputy Minister. Ms. Sierra Ramonado, you have up to 5 minutes.
Mr. Chair, and through you, again, thank the witnesses for being here. General Carignan, we hope that members never need this provision or this service. However, while we've been, since 2021, moving those cases, investigations to the civilian system, it's been since 1998 that the Canadian Armed Forces were investigating and prosecuting sexual assault. Is there a plan in terms of communicating to chain of command, local police, etc., the new measures once C-11 receives royal assent? For instance, I'm assuming that if you were to speak to a regular police officer somewhere in a small city in Canada who is who a victim has come forward to and says, I'm a member of the Canadian Armed Forces and I would like to report her. What is the provision in terms of educating them that it's not the military that is actually now going to be responsible for the investigation and prosecuting? Is there a communications plan, I guess is my question, with respect to educating civilian authorities and also victims of that new process?
So there's many folds to the question of communication. So this new way of doing has already been undertaken in the many provinces. There's been numerous consultations done with the provincial authorities throughout the last few years as this change came about. So this will definitely continue. On our side, we will make sure that internally to the Canadian Armed Forces that the new process is well understood, that the transition is occurring, and that the chain of command know where to go when complaints come forward. So this process will definitely be extremely important as we move forward in the transition. So the communication aspect of that will be absolutely key to success.
And Deputy Minister Beck, you mentioned the 24/7 support line for members, and many of you on this panel kept mentioning members. My question is, what if the victim is no longer a member of the Canadian Armed Forces and left because of sexual assault, and after this legislation passes decides to come forward? Do they still have, as veterans, access to the SRC or victim support or that the victims' VLO services?
For the question, absolutely. Veterans, families as well, families of the victim, families of the members. The communities that are involved, we know, are often deeply hurt by what has happened to their family members, so equally important that they have access to all of our structures in place to provide support. Again, that 24/7 phone line is for family members as well.
Perfect. And in terms of the implementation, the comprehensive implementation plan where 36 of the 48 recommendations from former Justice Arbour's external review has been addressed. I know that the goal is to complete them all by the end of this year. This bill also includes strengthening the independence of the investigation and the prosecution. Could you elaborate a little bit why that's important in terms of building back trust?
So as like concerning recommendation 5, more specifically, this was the reasoning behind Madame Arbour's recommendation is to ensure that level of independence from the chain of command and ensuring victims' agency over their own complaint. So that is all the reason for this this to proceed in that way. But also, there's many pieces to this. as we can see as well, the SMSRC is also independent from the chain of command and completely confidential, which is completely administered separately to ensure, again, privacy and ensure that victims have agency over their own process.
Thank you, General. Thank you, Mr. Raminato. I know time is coming out. Mr. Roseanne, you wanted to interject?
Just one quick question, and maybe my reply in writing, just the application of Bill C-11 when it involves multiple jurisdictions. As an example, the Reserve's 38th Brigade is training at CFB Wainwright at the Maneuver Training Center. And the sexual assault takes place. The victim is from the Winnipeg Rifles in Winnipeg. The accused is from the Armory in Thunder Bay, and witnesses might be from Regina and or Saskatoon. So you got the RCMP, you got different city police, you got the OPP. Who's doing the investigation?
If you could bring that in writing, that would be an important one. That's like multi-jurisdictional issues.
And that's where we get...
Yeah, and so it's a good question. So if we can respond to that, Deputy, that would be effective. Before we adjourn...
Similar examples.
If I could note, as we continue to study C-11, we should, I encourage all of you to bring forward the witnesses, hopefully by tomorrow, so that the clerk and the team can have some time to contact witnesses to appear before us. So please submit your witness list soon. For Thursday's meeting, the Deputy Commissioners of the Coast Guard are available to appear, so they'll be part of the first hour. And on the second hour will be NORAD modernization, and we'll have some witnesses appearing before that. So we're good there. November 4th meeting, we have a conflict because we're all going to be supporting the budget presentation that afternoon. So we're going to miss out on our committee on that day.
Arrange it.
And well, we'll see how we can proceed in terms of rearrangement. And our next meeting, though, will be October 30th on Thursday. So we'll proceed, and then we'll provide some notification as to what that will entail. C-11 is the intent as we go forward, so we could resolve this issue. Ladies and gentlemen, with your permission, meeting is adjourned.